there's a very strange paragraph in that NSA ruling on phone records, not an NSA ruling, a ruling by Judge William Pauley about the NSA's bulk surveillance program. I'm going to put this up on the screen and read it to you. And this is about the ability of people to challenge the constitutionality of the bulk surveillance. Check this out. This is written by Judge William Pauley. Regarding the statutory arguments, there's another level of absurdity in this case. The ACLU would never have learned about the Section 215 order authorizing collection of telephony metadata related to its telephone numbers, but for the unauthorized disclosures by Edward Snowden. Congress did not intend that targets of Section 215 orders would ever learn of them. And the statutory scheme also makes clear that Congress intended to preclude suits by targets even if they discovered Section 215 orders implicating them. It cannot possibly be that law-breaking conduct by a government contractor that reveals state secrets, including the means and methods of intelligence gathering, could frustrate Congress's intent. To hold otherwise would spawn mischief. Recipients of orders would be subject to Section 215 secrecy protocol confining challenges to the FISC, while targets could sue in any federal district court. A target's awareness of Section 215 orders does not alter the congressional calculus. The ACLU statutory claim must therefore be dismissed. That's a whole bunch of stuff, Lewis. Washington Post's Andrea Peterson sums up what this means. If you reread it a few times, what is being said here is that Judge Pauley says targets of these surveillance orders have no recourse to challenge the collection of their personal data because Congress never intended for them to know that their data was even being collected. Think about the legal argument that is being made there, Lewis. You want to challenge what we're doing to you? You can't, because you never should have known we were doing it in the first place, and Edward Snowden told you, so you can't challenge it. This, forget about the interdiction and putting spyware in people's computers. This is really the thing right here, Lewis, that we need to be focusing on.
This is incredible. I mean, it's like me poisoning your coffee every day.
Right.
And then you taking legal action against me because I've been doing it. And I said, well, he was
because
never supposed
someone
to
tells
know.
me, right. Someone
Right.
tells me, Lewis is poisoning your coffee. I go to a judge and I say, do you know what Lewis is doing? He says, hold on a second. You were never meant to know Lewis was doing this. You can't sue about it. Now, the difference is, of course, that this NSA stuff is an argument of constitutionality. No laws by statute have been broken, whereas poisoning me is a clear crime.
Well, of course, but we can still argue if what is happening is constitutionally legal.
Right.
So, that argument is still in the air.
This happened to me when I sent in my Freedom of Information Act request to the FBI and CIA asking for documents about me. They all wrote me back saying they had nothing. And they said, by the way, if we had stuff that we collected secretly about you, we wouldn't have to tell you in this letter because the collection was secret. So our knowledge, our retention of those documents would also be secret. Basically the exact same thing. And this is very serious stuff.